My name is Lauren Bagwell. This is my presentation. Today I'm going to discuss the topic of illegality of contract. Before we get too ahead of ourselves, let's go over a quick overview / outline, whatever you want to call it. Just sort of give you an idea of the path I'm going to be taking. Now, a lot of these terms that I'm going to be using are coming out of the textbook, which is called Business Law by James F. Morgan. It's also the 5th edition, if that makes any difference at all whatsoever. Not sure that it will, but now we're going to start out very, very generalized definition, which I feel can be confusing, so hopefully after this presentation is over, it won't be as confusing and it will actually be somewhat explained. So this is my outline, which is we're going to go over the introduction, have a general definition and overview. We're going to have the types of illegal contracts, the litigation disallowed, exceptions to illegal contracts, agreements to not compete, which is a kind of contract, and then we'll go over the references that I found. So, as this slide tells you, with the help of the end of the internet, I've somehow managed to find a good amount of detail on the subject of illegality of contract. As a general rule, which this is the definition, says, as a general rule, the courts will not aid either party to an illegal contract. Usually no action can be upheld on the contract. A party who has performed in whole or part is typically not entitled to recover by way of restitution. However, several exceptions to the rule can and have been established, and occasionally an action can be upheld on the contract even though it can be tainted by illegality, and in certain situations a party may be entitled to restitution. Now what this means is that when the courts are brought the parties, which means when the parties come to the courts, but the parties are of an illegal contract, the courts generally don't help either side. They usually don't even enforce any actions at all on the contract, especially since it's an illegal contract. If it's an illegal contract, really the law obviously has nothing to do with it if it's illegal. And anyway, a party who performed any part of or even all of the actions listed in a contract usually isn't entitled to recover at all, which means if someone said they were going to pay you for, say they said they were going to pay you to mow their huge lawn, and it was some sort of illegal contract, and you signed it and you went into it, and then part of the way through they just decided, I'm not going to pay you. Really what that means is you just won't get paid, and they basically got free work. So, which kind of sucks, but which means basically payment that you may have been promised, or that a person may have been promised, just isn't received. They just don't get it. However, there are several exceptions that have been developed and established. Occasionally an action can be upheld on the contract despite the fact that it's an illegal contract, and in some cases a party can or may be entitled to restitution, but that's very, very rare. Sometimes you can take the contract to court, and the judge will be like, okay, see, this makes sense that they would need, or that they should be able to, the contract should be upheld, basically, is what I'm trying to say. So we're gonna go over the types of illegal contracts. Researching these was probably one of my favorite parts of the semester, but I digress. One type of illegal contract is any agreement that's made in violation of public policy. The definition is a common law rule prohibits a contract based on the activity or prohibits the activity itself. The directed activity is contrary to a particular public policy. The common law rule may be adopted or modified by the statute. An example of one of these would be procedure unconscionability, substantive unconscionability, and the covenant to not compete. The covenant to not compete actually is going to be discussed later on in this presentation, but I also have some other, as you can see, I have some other examples which I found in the book that I won't be going into as much detail on. Another type of illegal contract is any agreement that's made in violation of a statute. The definition for this is a specific statute prohibits a contract based on the activity or prohibits the activity itself. An example of this would be like gambling and that sort of thing. There's some other examples that I also got out of the book listed as well, but pretty much this one pretty much speaks for itself. In that it uses a gambling as an example. Litigation disallowed. What is meant by litigation disallowed is basically that the courts leave the parties just as they found them, meaning that whatever occurred because of the illegal contract is merely just going to be left alone, and one party may be better off because of the illegal contract than the other, but that is just like the example that I gave previously, where, you know, someone pays you to mow your lawn or mow their lawn, and you just don't get paid for it, and you just got the free work, basically. The book says that, as a general rule, they won't allow any litigation associated with the illegal contract, and they are the courts. This means that if an illegal contract is executory, neither party may enforce performance by the other, which means that if it's an illegal contract, you can't make someone participate in it, pretty much. If the contract is executed, the court will not order a rescission and will not allow recovery of what was given in performance, just like in the previous example where they didn't pay you to mow their lawn. You're just out the effort, pretty much. To put it simply, a party to an illegal contract cannot recover damages for the breach of some contract. So, like, if you performed on what was in the contract, you can't recover the value of your performance, or you can't recover any property or anything that you gave to the other party in the contract. So, which really is sucky, but that's just the way it is sometimes. There are generally 4 exceptions to litigation disallowed that generally prevent the granting of any recovery from a legal contract. These are 4 exceptions to that. First of all, if a person falls into the category of those for whose protection the contract was made illegal, which is our first in the list, they can acquire restitution of what they paid or parted with, or anything like that, and sometimes they can obtain enforcement of the contract, which means that even if the contract was illegal, they can sometimes the courts will be on their side even though the contract was illegal, and they will get what they were promised out of the contract. For example, both federal and state statutes require that a corporation has followed certain procedures before anything that's securities, I think is what the book said, which was sort of like bonds and stocks and that sort of thing. Before those can be offered for sale to the public, there's certain procedures that they have to follow, and sometimes they are extremely, extremely difficult to get through, just because if they fall into this category, it was for their protection that the contract was made illegal, so you just have to be very careful with that. The second exception that I have listed applies when a person is induced by fraud or duress to enter into the illegal contract. In these cases, courts usually don't regard the defrauded or convinced, or whatever term you want to put there, whoever was forced into the contract, they usually don't regard that as being an actual participant in the wrong of the contract, and sometimes they will allow them to recover by ways of restitution. There's another thing that I cannot pronounce for the life of me. It's the third one on the list, and it's a doctrine that sometimes provides a remedy of restitution to someone who has been a party in an illegal contract. And the definition for this, because I think it's in Latin, the definition for this is quite literally a place for repentance, what was the one? An opportunity to change your mind, I think is what the other one was. And it basically just says that within very strict limits, you can withdraw from the contract. And this fourth one actually goes right along with it. A person who withdraws before actually having performed any illegal part of the contract, you can rescind it, I believe is the term that I'm looking for, and you can acquire the recovery part of your performance. So if you were to withdraw from your contract with the person whose lawn you were mowing before you formed any illegal part of the contract, technically you would be able to acquire the recovery for that, meaning you might get paid for it. And I know that's probably a really overused example, but that, anyway. Moving on to this next one, agreements not to compete. Now, these are an agreement that sometimes is legal, even though it can be a restraint of trade or something of that sort. There are types of contracts that can, depending on the type of the contract, they have a certain purpose. Excuse me. I have 3 examples that I'm using out of our book because I really couldn't think of any other examples, but there are 3 types of contracts that I'm getting from the book. And the types of contracts are a sale of going business, leaving a business, and employment. With the contract of sale of going business, this ensures that the seller of the business doesn't start another business that competes with this other business. So say you lived in a town where someone owned a restaurant and they sold it. They couldn't exactly, with this contract, go along behind the back of whoever they sold their restaurant to and open another restaurant that's going to compete with the restaurant that they sold, if that makes any sense at all. Leaving a business, this type of contract ensures that a partner, a member, or some type of owner of a business doesn't compete upon leaving their position at the business. So it makes sure that they just don't go along after leaving, however you want to put it, after leaving this where they are, and find another place, and basically, because they have so much information about this business, go and give it to someone else, and then you're just stuck. Like, they'll give someone else your information, and then they can just sabotage you, basically. An employment contract basically makes sure that an employee, once they leave their position, they don't go compete with where they formerly worked with a different employer. So, say you worked in a restaurant, you worked at McDonald's, and you left your position at McDonald's and you went to work at Burger King, and you were just helping Burger King outsell McDonald's. It's just, an employment contract typically helps to ensure that that doesn't happen. We have some other there are some other examples that have, but you know, I feel like this is going to be too long already, so I don't want to. The references that I have gotten for this, or that I came up with, that I went and found, that I used, that I got my information from, are government contracts, illegal contracts, jurisdiction of Court of Claims to grant a quantum merit recovery, Yosemite Park and Curry Company versus United States, 582 Federal 2nd, 552 CT C1 1978, which I received from digitalcommons.law.byu.edu. It was a case reading, essentially. It was just like in the book where they have cases. And I just found it very interesting, and it really helped me to understand what I was going over. The next one was also, it was a more educational reading. It was Illegal Contracts and Efficient Deterrence, a study of modern contract theory. And I received that from HeinOnline.org, which was extremely useful, actually. I used a lot of information. One of my definitions that I used in my other slides was from HeinOnline.org. And then we had the unconscionable contract or term, which also was received from that website. Like I said, I loved that one because it was just so fantastically put together and easy to maneuver, and it was just fantastic. Contract law in the welfare state, a defense of the unconscionability doctrine. I want to say usuri, but I really don't think that's right. And related limitations on the freedom to contract, which are received from journals.uchicago.edu. So that's my presentation, and thank you very much.